Do I have to tell the Social Security Administration about all of my medical problems if I'm claiming Social Security disability benefits? Now, filing a Social Security disability claims involves filling out a lot of forms and a lot of medical documentation, because ultimately the Social Security Administration is going to get a copy of your medical records, the test reports, even operative reports, in determining your entitlement to Social Security disability benefits. Now, as a matter of course, I recommend that clients tell the Social Security Administration about all of their medical problems, even if they don't necessarily think that they are disabling. Many times what I am arguing to the Social Security Administration is that my clients' impairments may be individually disabling, but also in combination are disabling. So let's say you have a heart condition and you have diabetes, but your diabetes is under control. Should you list that as a disabling condition? Now, the diabetes in and of itself is not going to get you your Social Security disability benefits because it's not disabling. But the combination of the diabetes and the heart condition could very well, in combination, qualify you for your Social Security disability benefits. That's why I think that it's important to disclose all of your medical problems so that it can be sorted out. Now, the Social Security regulations also require that you inform Social Security of these conditions and submit all known evidence that relates to whether or not you meet the Social Security's 5-step sequential evaluation test. It's the relates to that I think requires you to advise the Social Security Administration of all the medical conditions, even though you may not think they're disabling. And what you need to understand is that your attorney has an obligation to submit medical evidence. I'm required to obtain evidence and submit all the evidence, including factual information, medical source opinions, medical reports, pharmacy records, that relates to the question of whether or not you're disabled under the terms of the 5-step sequential evaluation. And we can get into big trouble if we don't. So there is no hiding the ball. You shouldn't be hiding the ball with your attorney, and you certainly shouldn't be hiding the ball with the Social Security Administration. So if your attorney asks you to provide a complete list of your medical providers so that they can obtain those medical records, be honest. Don't think that, hey, that's not disabling, I don't want to spend the money to get those records. That's not the way it goes. You also need to understand that once the attorney gets access to your Social Security electronic file, we're going to be checking the medical records that are in your file as compared to what you told Social Security or what you told us about your medical treatment, including any mention in the records of other doctors' names or referrals to specialists or hospitalizations. Obviously, being honest and being complete with your medical history is key to getting your Social Security disability benefits. If you have any questions about your rights to benefits or if your claim has been denied, remember, you'll only have 60 days in which to file an appeal. Call us today at 727-894-3188. Don't delay.